It's a beautiful day, and I am delighted to welcome you to this new episode of the Computational Antitrust podcast. My name is Thibaut Schreppel. I am a faculty affiliate at Stanford University Codex Center and associate professor of law at the VU Amsterdam and the creator of the Computational Antitrust project, which explores how legal informatics can benefit antitrust law. The project brings together over 65 competition agencies and 50 academics on the advisory board. Every month or so, we publish an academic article on the subject of computational antitrust. You may find all of these publications in open source at computationalantitrust.com.
I am Teodora Groza, and I will begin by introducing our speaker today, who is someone that hardly needs an introduction for anyone working on antitrust. Eleanor Fox is Professor Emerita at NYU Law School and the author of some of the most influential books, chapters, and articles on antitrust laws and institutions. On top of her academic achievements, which are numerous, she served as an advisor to the DOJ and to various young antitrust jurisdictions, and this has earned her the title of the Antitrust Ambassador to the World. Our discussion today picks up on many of the threads of Professor Fox's work. We will talk about what challenges competition agencies from the developing world face, also about how they could be better positioned than their global north counterparts to experiment with some computational tools. We'll also talk a lot about what are the biggest challenges these agencies face, and also at the very end, we'll zoom into some of the most pressing substantive principles of antitrust, varying from the fundamental assumptions the law operates with and how the law has changed in the past and what has influenced these changes.
You have edited a book on the design of competition agencies. And so we were wondering, one, what are the main findings, the main takeaways of the book, and what can we learn from it in terms of modernizing competition agencies?
Yes, thank you. So the book project, which I did with Michael Trabilko, is a very interesting project. We looked in depth at 8 different kinds of agencies from all over the world, and then we added a few others that we did less in depth, and considered whether there were standards for best practices in the institutional design. And we concluded that there are a number of institutional designs that can be just as good as one another. The most common is that the agency has either a board of directors or a commission that it presents to, and there can be an appeal from the commission. Less common but not uncommon is our U.S. Justice Department model, where the agency brings cases to court. The main considerations that was our big takeaway was the big problems were with how the agencies implemented the design. Sometimes it was creation of the design when there were conflicts within the system. For example, the head of competition policy also sitting on the commission board. But most of the time, the big problems were, for a number of countries, it would be corruption problems or lack of capacity and delays, lots of inefficiencies in priorities. For example, being compelled to vet a certain large number of mergers, and all of them would get cleared without even conditions, and that used the whole budget of the agency. That would be a big problem for smaller agencies. A huge number of problems in delays, and sometimes purposeful delays, because the powers at the top really didn't want the case to get decided. And sometimes delays because a competition tribunal had absolutely no expertise and just kept putting off the results. So all of those were cautionary tales, things that could be overcome with more budget and more skills training and less government interference and more actual independence of the agency. And when I say actual, there are a lot of agencies that read as though there's independence, and there really is not, that a government and cronies have control.
Yeah, I mean, we rarely hear from an agency bragging about the fact that it would be absolutely not independent from the government, right? Usually they do say the opposite. But coming back to what you said about the courts, would it mean that we would also need to invest in the court system to make sure that they can welcome what the agencies will bring to us, if it's computable evidence and other type of new AI-generated evidence?
That is right, yes.
All right. So now, making it even more specific, you worked with agencies around the world, including several competition agencies in Africa. And I wonder, what are the specific challenges that those agencies in Africa would face when modernizing their processes and tools that you think will not necessarily arise in other parts of the world?
Yeah, so I can tell you what I think those challenges are, but most of the challenges actually have a counterpart in the rest of the world. So agencies in developing countries have real challenges in resources and skills. That's part of resources, both human and financial resources. Those are huge, huge challenges to begin. I would like to put aside the agencies that are really dysfunctional, because there are some agencies, some, for example, in West Africa, that are really not functional. They might have 4 people in the office, and the government doesn't want them to promote competition in markets and would prefer price fixing. And I would put that to one side because that's a very separate problem. So for those who are really on track of trying to help make the markets work, scrapped of resources is a principal problem. Another principal problem is, depending on the country and the context, the institutions, the business institutions have not grown from ground up. They're usually looking at the aftermath or the still existence of state-owned enterprises. And in addition, there's huge majorities of people who have been left out of the economic process because of discrimination, like apartheid, but also even the non-apartheid countries. Huge majorities left out because of the workings of colonialism. And so part of their challenge in making their markets work is to get inclusiveness of their population. And that adds a different lens to how to get their markets to work. So it adds an element that their foundational substantive formulations are a little bit different. And it is a challenge when the agencies want, on the one hand, they want to do international practices, and you and I can fill that in, but they also want to have their laws serving what they need to do for their people. And that's a kind of conflict that they don't all resolve perfectly. And in addition, when they go about it, even in the best possible way, it's an additional challenge. For example, and here's where computational tools can certainly come in, to determine the extent to which they can apply a value of inclusiveness, which usually means harsher on exclusionary practices, for example, for the one big good example. How far can they go in that direction without hurting consumers? Are they mostly helping consumers, or are they hurting consumers? This is one area which translates into everybody's antitrust. It's one area where at some point there's going to be a trade-off. Where is the trade-off? We don't know. We make big assumptions, and with better tools for analyzing the data and even predicting from the data, we could know better where the trade-off is.
Would you also say that those agencies have an issue in terms of making sure that people would understand what they do, which I guess would be an argument against the use of AI, right? Because it would be seen as being too technocratic as opposed to what the people, would be willing to accept. Is that a challenge for them?
Yes, I think it's a challenge. I think there are instincts. So let's suppose a dominant firm. And the dominant firm does practices that make it much harder for new firms to get into the market. And there's definitely an instinct when that happens, it's wrong. Sometimes those activities of the dominant firm are pro-competitive, and sometimes they're not. And incidentally, if you're in an economy, which is many developing country economies, where the dominant firms are state-owned or were state-owned and grew from privilege, not merits, it's more likely that the exclusionary practices will not be justified. So there's some continuum there, but that just goes to present the point that many developing countries are trying to develop a slightly different jurisprudence, and how to develop it could actually be influenced by computational tools. And your last point, there definitely is an instinct when there are exclusions, when entrepreneurs that at least look like they're efficient, they're going to be efficient. If they can only get a good pathway into the market, if they are excluded, there's a very strong presumption that they shouldn't be. And if AI shows that consumers are losing, that will be hard to take. But maybe the AI won't show that. I mean, maybe the AI will show that exactly those practices where the meritorious, I'm calling them meritorious or potentially meritorious entrants, where they're persistently not able to make a good pathway into the market.
Yeah.
You get AI maybe to show that this is not only bad for the economy and the integration of the economy, but it's bad for the consumers in the economy. Yeah. So maybe the more times you will get those situations where using the tools will be helpful for what the people's instincts are, the more you get acceptance.
So you gave us a great overview of the challenges that non-European markets and non-Western markets face and how those differ from what we see in our jurisdictions. But I want to push you a bit further in terms of how the agencies overseeing these markets could benefit from computational tools, and where do you think they should steer their resources in that respect?
So, of course, that's a great question, and it depends on how available are the tools and how easy they are to use, and whether it costs a lot of money or not to get the tools, whether they have access to the tools. If they have access to tools at a reasonable price and can use them, and they have the capacity to use them, the skills capacity to use them, there are a few good answers to your question. One relates to projects that are being done in Africa right now, which are the following. And what I'm referring to is projects being done at the University of Johannesburg by the Research Institute, CRED, which is directed by Thando Vilakazi and was directed by Simon Roberts, who's still very, very active in it. And they do a lot of on-the-ground research. And incidentally, anyone doing a lot of on-the-ground research could, and they probably do, use the best available tools. They have detected through a lot of research work that, take agriculture and food, which they're working on, the prices of food are artificially high, and they're higher in Africa and many African countries than in many places around the world, even though it's a problem all over the world. So why are they higher in Africa? They've done research in particular markets. It could be particular seeds or fertilizer or poultry. And noticing suspicious trade flows. For example, one country has a surplus, the country next door has a deficit, and the goods are not moving to the country next door. And why not? I mean, it's very suspicious. And you and I would say it's probably a cartel. And if it's not, it's government action that was obtained, procured by vested interests. That's exactly the area they're working on right now. It requires cross-border collaboration. It requires a lot of detailed information and data. And so if with the finest tools, I'm sure they could do the job faster and better of finding the data, they have found suspicious flows, but maybe computational tools can find much more of the suspicious flows. And that is very descriptive, finding data that will tell you what exists. And then there's the question as to why it exists. And I suppose, because I am not an expert in the various computational tools, but why it exists, one would want to look at the statutes of the various countries. And in fact, they have found perverse statutes that sometimes preventing exports when it's just totally perverse. But identifying causes that would be the most likely that you could even detect, like what a statute says that might be an export limitation. If you don't find that, I suppose your tools can lead in a direction to make what you might call tentative conclusions. There must be a cartel. This would not happen without a cartel. And that's also partially just getting the data and seeing what the data says. But I'm sure your tools can also, this would be machine learning and artificial intelligence, have ideas and good ideas of, say there are no particular government barriers and you find these suspicious flows across border, that there must be a cartel. And so you have artificial intelligence that says, you can tell me, I'm not sure how it would say it, but there must be a cartel, or 90% sure there must be a cartel. And then if that's the only evidence you have, can you win a case? What do you need in court?
I think this is a great answer precisely because most of the conversation tends to assume that the only agencies doing computational tools and trying to develop them are those located in the Western world because they have the financial resources to do so. But as your example shows, we have these developments occurring elsewhere in the world. And I want to push you a bit further here and ask you to imagine ways in which these agencies from the global south might be even better positioned in certain respects than their counterparts from the global north to experiment with AI and computational tools. Can you think of any factors which would put them in a better position?
Well, in a way, I would say yes, before I say particular factors, because there's more low-hanging fruit. There are more cartels. There are cartels all over that they cannot catch. Now, sometimes they cannot catch them as a political matter because the political leaders often either influenced by their own pocketbooks or influenced by the vested interests and sharing the gains with the vested interests. They don't want you to catch them. So without being able to work on that political problem, you'd want to know the ones that the politics is not standing in the way. And indeed, sometimes if you can put out the information to show the costs of something, like the costs of not going after this cartel, sometimes you get the people on your side to say, yes, I want cheaper food, and this is standing in my way. At a very basic level, using either just what we might call what was the use of computers before machine learning, which would be very normal. Everybody's doing it, or the machine learning. I think these tools can be extremely helpful. To the extent they're not being used, they have to be taught how to use them, and they have to be available. They have to be accessible.
That's a major subject, right? We've been trying to push some antitrust agencies, and we see the first initiative in the space to share what they have. When we also discuss with other competition agencies, we see that some of them are not willing to accept what will be coming from the outside, whether from companies, competition agencies, or independent experts. They want to develop anything internally, which I could understand for political reasons, but it seems that you could see a kind of a network effect and benefit in at least having some agencies working together. Now, on a more substantial level, so taking kind of a step back, but not really, because you talked about how the state could interfere with competition, which is a problem in the global south, but also in the global north, as we know. It seems to me that it is a space where we may want to use computational tools in how we design regulation and monitor the impact of those regulations, which I will call complex adaptive regulation. But regardless of the name, what do you think of this idea of putting regulation on the markets, monitoring the effect of those regulations, which I think will trigger interesting conversation as to which data do we need, can we get the data, and what are the thresholds, and making sure that those regulations will adapt to their own effects?
Yes, so first of all, there would have to be the need for regulation. And assuming that, yes, that's a very, very good idea. So I'm thinking now about DMA, and DMA is doing this. And DMU, CMA is doing it more. Getting the companies in to comply with the do's and don'ts, and asking them to say how they will comply and if they can comply. And they will sometimes say, I don't want to comply, and it's hurting us, and it's hurting our business, it's hurting consumers. Taking account of all of this, even if they don't believe it, or they don't believe 90% of it, but there's a little germ of truth, and adjusting the regulation. So that really is the modus operandi in the CMA, to adjust the regulation to what the gatekeepers can do usefully.
Thank you. So you push towards substance. I want to push even further towards the ultimate principles of antitrust, if I may. So, Professor Fox, about 10 years ago, you wrote a very challenging article which is called Against Goals. And it's one of my favorite antitrust articles ever, because its message says that the debate we have about goals, and one we still see today very prominently, tends to obscure a more fundamental debate about what are the economic assumptions that antitrust operates with. I'm wondering, do you think computational antitrust can help us move towards this bigger and more important debate by forcing us to ask what assumptions about markets and economic behavior we can plug into our computational tools, in the sense that when we develop these tools, we need to configure them to an idea of how markets work, which ultimately requires us to face this question?
Yes, that's a good point, and I think it can help. I think there's a sense in which it can and a sense in which it can't. I think there are some very strongly held views on political economy and the best balance of government intervention and not intervention. Very strong views. And they don't seem to change over time. They have, as I noted in my US casebook, sort of at the very beginning, my casebook with Dan Crane, towards the beginning, we show how the very same ideological sentiments that were demonstrated by the Supreme Court justices in the very earliest cases, like Justice White and the first Justice Harlan, are replicated today. And they absolutely influence a formulation of antitrust, which involves how much intervention, how much you trust the market, how much you don't trust the market, how much you believe that there is an impetus from small and middle-sized business that has to be recognized, that is an important market force, that also goes together with a notion of helping people who are not the powerful people. I think this will always continue to be so. But I also believe that some of the dissensions that boil down to particular cases can be resolved by better information, and computational tools can help the better information. So I'm thinking of, for example, the economists in the hot tub, the sides, the plaintiff and defendant get their own economists. The economists' whole worldview is based on certain assumptions going in, and the hot tub should reveal where they are not joining issue. Now, maybe computational tools can sort out that from the beginning, even before a hot tub, can say this is exactly the point at which experts with these different starting premises are going to disagree. I could say one of those points is vertical integration, vertical mergers, and double marginalization. Whether double marginalization is a huge point or a very small point, that doesn't usually happen. And that tends to fall on ideological lines, interestingly. And maybe more information with the data and good predictions from the data that can be done with computational tools could narrow that gap.
I do have two quick reactions on that. The first point, we see the exact same in Europe. From, 40 years ago, people talking about ordo liberalism, and you still have some people talking about it, but now you see that maybe this concept kind of shifted into another one, which would be the one of self-sovereignty. We even have a minister of self-sovereignty, economics and self-sovereignty in France. So it's interesting to see that some ideas, they morph, shape into new ideas, but they similarly are the same. As to the second point, there is a paper that I like very much by the economist Brian Arthur. I think I've never mentioned that on this podcast, called Economics in Norms and Verbs. And the point he's making is that using computational tools and computational thinking, you can actually better forecast and understand dynamics on the market, as opposed to using, algebra that is more static by definition. So it seems indeed that with new tools comes new thinking, and maybe that those are reasons for hope. But Theodora, I give you back the floor.
Could I just add one point coming out of our conversation in the last 5 minutes on access to information and data? A lot of computational tools do best with the most data. And the most data is in the hands of fewer and fewer firms. And this can be a real problem if poor agencies in poor countries want to use machine learning tools, but they don't have the data. And then the next step problem is, should they have access to data? Should they have access to data by very large firms? Of course, it's not just developing countries. This comes up in DMA. DMA gives some access to data. This is a very controversial issue as to whether companies have to share their data.
Yeah, with business secret and all the things we've been discussing also in the context of the AI Act. So probably a conversation we will not solve on this podcast. Sorry to disappoint all of our listeners. Theodora, back to you.
We won't, but we can solve other equally important questions, I guess. I just want to piggyback on the discussion we've been having most recently. And I think you mentioned Professor Crane just before. And something he said at one of our annual conferences was that antitrust operates currently as a big inference machine, in the sense that we have all these presumptions about what effect practices have, but not enough data and capabilities to do case-by-case assessments for all of them. And here at the Computational Antitrust Project, we think that this is the future of antitrust, in the sense of producing data processing capabilities which will allow us to have more nuanced assessments. But given that we talk about the future, I think it's also required to look at the past. And if we look at the past, we see that antitrust laws have changed tremendously because they were pegged to the evolution of economic ideas. Now, if you were to look at how antitrust has evolved in the past, do you think that these changes were linear, in the sense that there was constant progress towards better outcomes, or that some developments were not necessarily evolutionary but rather regressive? And I know it's a huge question, but if anyone is able to answer that, it's definitely you.
Oh, goodness, thank you. So my answer, however, is I want to question the premises by saying antitrust has changed because it's linked with economics and economics changes. I think that the changes in antitrust have not come about so much, this has to be a footnote there, through progress in economics and economic thinking as political economy aspects. So, and people's view of power in the world or in the country, and corporations' use of that power to abuse the power. So in the US, of course, we've had a few major changes. We had the enactment of the Sherman Act in 1890, when modern economists might say, oh, well, economics wasn't really developed then, and we have made so much progress. And then, and it was political economy. I mean, it was adopted because of political economy and a concern about too much power, even though you can easily map it on to anti-cartel. 1960s, the U.S., our period of civil rights and working for the less powerful to bring them into the system, and aftermath of the Second World War, fear of concentrated power because of political reasons that Hitler used the cartels. And then with the Reagan administration, we had overregulated. And Reagan ran on getting rid of too much regulation. So it was this big idea of cutting back antitrust. We should realize that we now have found that in the 1980s, in the name of economic progress, some ideas were thrown out that were very good ideas then and are just coming back now. For example, the idea that the first Reagan merger guidelines were all about we should prevent mergers because the companies might cartelize or something akin to cartelization. It was only about that. It wasn't until years later that the economists said, oh, we now have enough information to know that when two firms that are very close competitors of each other merge, they're taking competition off the market that might hurt consumers. That was always in our law before the Reagan administration. It was thrown out on this move to shrink our antitrust law. So I think on the grandest conceptual scale, our laws aren't changing because of economic, quote, progress. Even though so I said there had to be a big footnote, because there are such things as economic progress, but the grand scale, they're not changing because of that. It's more like the details of the cases and how you prove them.
Let me conclude with a bonus/fun question. Let's imagine that you could design a magical algorithm that will detect 100% of one specific antitrust violation, right? So every time companies would do that practice, we will find it and we'll be able to punish it. Which practice do you wish that would be? Meaning, I guess, which practice you think is the worst and we should absolutely invest in our capacity to detect it?
Oh, so I have to say there are two categories that would be the worst, because cartel activity, which is, of course, presented as the worst in many, many jurisdictions around the world. Cartels, yes. Sorry, I'm not answering exactly. Because I think that vested interests co-opting governments to get their way, to harm trade and competition, and bring in the trade because it can't reasonably be left out. I think that's probably our worst practice. And it's the trade and competition practice that is designed and procured by vested interests to help the vested interests and not the people, that should be deciphered and made illegal.
You're pleasing me very much. I had a discussion last week with a couple of friends, and the question we try to answer is, if we were at the head of any agency, what would be the first thing we would do? And what I answered is that I would create a task force precisely in charge of identifying regulations captured by the industry and try to then, lobby my way into getting rid of it, which is not easy. But the beautiful thing about it is that, in a sense, you could create this program all over the world. I would do that if I was in the US, in Europe, in Africa, Asia, and other part of the world. So to everyone out there, I guess this is a question for you. What would you do? What would be your top priority as the head of an agency? And I guess you will have a similar answer, because you would say, this is the worst kind of practice. On that good note, it has been a true pleasure discussing those issues with you. So thank you so very much for your time and for everything you've been writing and publishing, and all the people you've been helping behind the scene. So thank you, Eleanor, very much. And to everyone out there, take care of yourself, and if you can, someone else too. Bye-bye.
Thank you both very much. Thank you for your great questions. Very thoughtful. Thank you.